Nicole Shotwell versus Shane Valicenti.
For the record, this matter is before the court. The defendant's motion to modify parenting time. This hearing is being conducted via Zoom. Present is Attorney Eric Chappell, representing the defendant. Petitioner Shane Valicenti. Mr. Valicenti is present. Is Nicole Shotwell present on audio? It appears that she is not. Good morning, Mr. Chappell.
Good morning, Your Honor.
Good morning, Ms. Brower.
Good morning, Your Honor.
It appears that the copy of the motion notice of hearing was mailed to Ms. Shotwell and address of 340. Ms. Brower, is that the address that the front of the court has on file for Ms. Shotwell?
Your Honor, we do have a different address for her.
You have
Okay.
Latour Street?
In Brownstown, yes.
Yes. So, Your Honor, if you look at the certificate of service on the motion, we sent it. We initially sent it because that was the registered address for her at the front of the court. When we had a referee hearing, well, she had filed a parenting time complaint, and a referee hearing was scheduled that she did not attend. Mr. Valicenti let me know that she resided at a different address. So we then did the proof of mailing on the 23rd of January to also send it to. So I think we've covered both addresses at this point.
Thank you. I do note that the form notice appearing in motion scheduling matter for today's date at 8:30 via Zoom, and it reflects the court's Zoom ID number, was mailed to Ms. Shotwell at the address. That's the address on file, correct, to Ms. Brower?
Yes, Your Honor.
And subsequently, another copy of that motion was mailed to Ms. Shotwell at Monroe. The matter was set for 8:30. It's now 9 a.m. The plaintiff has failed to appear. Mr. Chappell, when was the last time Mr. Valicenti had any contact with Ms. Shotwell in terms of exchanging the child recently in the last couple of days?
I believe, Mr. Valicenti, go ahead and describe your last contact, please.
I have the last message that I received from her, Your Honor, was on the 8th, and it was letting me know that she had gotten a third new phone number in the past 30 days. And that is that's the number I just called during this hearing to try to reach her. And I also, which the voicemail was full, and I also texted that number to try to contact her while we were in the waiting room or the breakout room.
Right. So it's been almost 2 weeks ago that you last had any conversation with her.
Correct. But I do know that she was aware of this hearing personally.
How do you know that?
We spoke about it after her calling me just after the referee hearing. We discussed this. I think Ms. Brower was speaking with her that day when she was calling to find out what had happened from missing that. She got the information for the new court date. She let me know that at the time.
Yeah, Your Honor, I believe Ms. Brower had indicated that she had contact with Ms. Shotwell after she failed to appear for the referee hearing. And Ms. Brower also let her know about today's date and, the time of the hearing.
And that referee hearing was January 23rd. Is that correct?
It is. Yes, it is.
All right.
It was. Yep.
All right. The court appreciates Mr. Valicenti. You're attempting to call her this morning because we do like her participation. In any event, the recommendation of Ms. Brower this morning is that the plaintiff mother's parenting time be suspended until she petitions the court. And that further, the parenting time show cause complaint filed December 12, 2023 be dismissed, and the minor child Giovanni shall continue in counseling. Mr. Chappell, is this recommendation acceptable and cover everything?
It is. It is, Your Honor, and I believe it does cover everything. Thank you.
All right. Well, the court will adopt the recommendation. Now we'll conclude this matter. Good luck, sir. Thank you,
All right.
Mr. Chappell, for the rest of the day. Thank you, Ms. Brower.
Thank you.
You're welcome, Your Honor.
Natasha Hayes versus Jody Moss.
Record this matter is before the court on the defendant's objections to a referee recommended order that a bench warrant issue for his arrest to find the period of referee hearing. This hearing is being conducted via Zoom. Sir, you're Jody Moss.
Yes, Your Honor.
Okay, is Natasha Haney present on audio?
She's not present, Your Honor.
All right, thank you. She has not appeared this morning. Her attendance is not necessary. However, Mr. Moss has conferred with Ms. Rebecca Hicks, attorney for the Monroe County Family Court, who's also present on Zoom this morning. Next, Ms. Hicks, you'll be submitting to the court a proposed order.
Yes,
There
I
it is.
just
Okay.
pushed them. Thank you.
Yep, I just see it. All right, Mr. Moss, it's good that you filed this objection. The Ms. Hicks is recommending that recommended order be rescinded and canceled, so there'll be no bench warrant. But it also makes reference to an enforcement order dated February 21st, 2024. I don't know what that order says, but I'll see if I can find it here in the court file.
It should be an on base, Your Honor, under the FOC motions and orders queue, but you have quite a few things in there. I think it's the bottom one.
Okay. Yes, okay. The court's also received a proposed uniform enforcement or support enforcement order, Mr. Moss, which states that you have arrearages, some audit about $1,700, and then you did appear for Zoom today, and it's also noted that an active income withholding order is in place. Now you're ordered to appear before Ms. Hicks for review on April 30th, 2024 at 1 p.m. And the authorization set aside the bench warrant, that is set aside. You need to keep paying the minimum that current support. 167, try to pay $200 a month so you can start to reduce those arrearages.
Yes,
Right.
sir.
Do you have any questions, Mr. Moss?
No.
All right.
Not at all.
Keep in contact with Ms. Hicks, and you need to make regular, consistent payments. You want to get off her docket by making regular periodic payments. You don't need to be reporting every couple months.
Your
And if you
Honor,
move,
I was behind. I was
Okay.
behind tens of thousands of dollars and got caught up. So I'll get this caught up real quick. It's my fault I'm behind, but I'll get it taken care of.
All right. And if you move, you need to keep in front of the court informed of any change of address. That's real important.
Yes, Your Honor.
All right. All right. Anything further from your standpoint, Ms. Hicks?
Nothing further, Your Honor.
All right. Okay, the court will enter both orders. And that will conclude this matter. Mr. Moss, you're all set. Have the rest of the day, you'll be mailed a copy of these orders. And then to make sure
Thank you,
appear
Your
for
Honor.
Ms. Hicks and April 30th at 1 p.m. for review.
April 30th, 1 p.m. Yes, sir.
Is Ricky Dennis present on audio? All set, sir.
I believe so. He's showing up, I believe, as the phone one marked Ricky.
Mr.
Mr.
Janis,
Janice, are you there?
Yes, Your Honor.
All right. Is Carrie Lynn Murray present on audio?
Does not
Appears
appear
that
so.
I'm sorry?
Does not appear so.
Okay, the court was going to say it appears that she has not appeared. Mr. Romberg, you've created some confusion on this case, but I think we can work through it. You were to notice for entry a proposed default judgment on today's date and time. You didn't do that, but already submitted under the 7-day rule.
I apologize. I was unclear as to what you wanted me to do, Judge.
My notes are very clear in the court file, but in any event, the court saw that submitted on base on the 7-day rule. Mr. Murray did not object to entry of that proposed default judgment. Unfortunately, the court did not sign it, because if I would have signed it the other day and then it came before the court, she would have appeared today, we would have had a major issue, but it did create some confusion. And if we go through this. Again, this final pretrial conference was scheduled for 10 a.m. It's now at 10 a.m. Once again, Ms. Murray has failed to appear. She's repeatedly failed to appear for these proceedings. The notice to appear for this final pretrial conference, which the court mailed to Ms. Murray at the address of 127159, has not been returned as being undeliverable. It appears further that the proofs were taken by this court back on January 26, 2024. At that time, the court established jurisdiction. There's been a breakdown, no chance for reconciliation. However, I do not recall if Mr. Janis testified to the best of his knowledge that Ms. Murray was not now pregnant. Mr. Janis, when did you last have contact with Ms. Murray? Can you give me a month and a year? Has it been years?
Physical contact or talk on the phone?
Either.
Physical contact's been just a little over 2 years, and I want to say the last time I talked to her on the phone was about a year and a half ago.
Okay. To the best of your knowledge, Ms. Murray is not now pregnant. Is that correct?
That is correct.
All right. Mr. Rosenberg, you've been out to this home on 12. You attached to the pleadings a copy of the order for alternate service and someone's complaints. Did it appear that anyone was residing in that home?
Yes, Judge, it does appear that people reside there, but there were no lights on at the time. It's across the street from, and there's an assortment of abandoned or beat up cars that seem to change out there all the time. But I've never actually seen people there. I've only seen evidence of people living there. I probably drive past there 2-3 times a week on my way between Ann Arbor and Monroe.
Okay. So it appears to be a habitable structure?
Yes, Judge.
And are there the various vehicles? Do they seem to be different vehicles, or does it look the same as it is today?
Over extreme periods of time, they've changed, but recently they seem to be sort of the same vehicles.
Okay.
There used to be, because I know this because I drive past there all the time, there used to be some like 1980s or 1990s General Motors B-bodied cars there, but they're long gone, and that's not really relevant to this case. So they do change, but I don't know who they belong to.
All right. It appears that the court and counsel made every effort to make contact with Ms. Murray. Ms. Murray has failed to appear. The default was entered by the clerk of this court. On January 24th, 2024, a copy of that default was mailed to the defendant by Attorney Rosenberg. Once again, based on anything further, Mr. Rosenberg?
No, we haven't had any contact from Ms. Murray at all.
Okay. Mr. Janis owns real estate, is that correct?
I don't think
No,
so.
I do.
No real
I do not
estate?
own real.
All right.
No.
The judgment simply makes reference to property, doesn't define property, whether it's real or personal, but any property, each party shall keep the property currently in their possession, free and clear any claims on the part of the other. In any event, based on the testimony that's been previously secured and the complaint filed in this case, the court again finds that jurisdiction has been established and that there has been a breakdown of the marriage relationship, and there's no chance of reconciliation. Accordingly, today it is ordered by this court that the marriage between the parties be dissolved and judgment shall enter granting a divorce from bonds of matrimony. The court will sign the judgment. Mr. Rosenberg, you'll mail a copy of this judgment to Ms. Murray, is that correct?
I will. About how long will it
Please.
take? About how long will it take for it to migrate from your bench down to the court for me to get a copy of it and mail it?
Well, the court's going to sign electronically right now, so I presume they'll mail it out today or tomorrow, unless you want to come by and pick it up.
I was going to be in town later on today, so I could.
Okay. You can go down to the clerk's
But if you
office.
want, if you're going to mail it out, you can mail it out too. Either way is fine.
Well, you can check with the clerk's office. Please note that your judgment of divorce references a zip code for where that came from, but your other pleadings, your certificate of mailing, all say note that the zip code for Ms. Murray on your judgment, the first page of judgment is erroneous.
Okay.
And if you can mail it out with that for the record, because it's been submitted to the court electronically, so I cannot modify that. In any event, judgment has been signed. Good luck to you, Mr. Janis. And that will conclude this matter. Thank you, Mr. Rosenberg. Have a good rest of the day.
Thank you, Judge. You too.
Jordy
Thank you, Your Honor.
versus Schmitz
welcome.
versus Joshua Gibson.
The record this matter is before the court on the plaintiff's motion for to show cause, alleging denial of parenting time and video calls with minor children. The other matter before the court is the defendant's objection to an order of this court date January 24th, 2024. This hearing is being conducted via Zoom. President Attorney Alex Gilman representing the plaintiff mother, Ms. Shansensen Schmitz, and the plaintiff also here is Joshua Gibson. Are you present on audio, Mr. Gibson?
Yes, sir.
All right. Good morning. And Ms. Mayville, good morning.
Morning, Your Honor.
Good to have you back assisting the court, Ms. Mayville.
Thank you, sir.
Okay, Ms. Mayville from front of the court has conferred with all the parties and has provided the court with the following recommendation. That the parenting time to remain as previously ordered from the hearing of January 24th, 2024, with the following modifications to make plaintiff whole regarding denied parenting time. The following 6 Fridays, plaintiff mother shall have the minor children from 5 p.m. to 8 p.m. All changes going forward are to be done at the corner of Adams and 6th Street in the city of Monroe. Only family members shall be present at this exchange. There should be no significant others present during phone calls with mother. The minor children should not be placed on speakerphone during their conversations with the other parent. That is a recommendation. Essentially, it's for make-up parenting time. Currently, mother has parenting time every Saturday and Sunday from 4:30 to 7:30. Is that correct, Mr. Goldman?
Yes, Your Honor.
So that will continue. In addition, mom will have the next 6 Fridays from 5 to 8. All right, Mr. Goldman, is this recommendation good with your client this morning?
It is, Your Honor.
Thank you. Mr. Gibson, do you understand the recommendation of Ms. Mayville this morning?
Yes, Your Honor.
Do you have any objection to the court adopting this recommendation?
At the moment, no, Your Honor.
It's critical that you need to comply with and follow court orders.
Yes.
Not sure what prompted you, Mr. Gibson. Is the argument over a car seat? Is that was the issue? Is that correct?
Yes.
Have we resolved the issue of the car seat, Mr. Goldman?
I hope so, Your Honor.
Well, I don't want mom to be denied parenting time this Friday. Mr. Gibson, have we resolved the issue of this car seat?
I mean, I would prefer to buy another car seat, but like, I'm not gonna get in trouble. She'll still have her visit.
Well, Mr. Goldman, does your client have a car seat? There's some dispute as to whether or not it's a certified acceptable car seat.
It's police approved. She's had it reviewed by law enforcement. Mr. Gibson is imposing additional requirements that he's found somewhere on the internet.
Right.
Not internet, any CPST.
All right, well, Mr. Gibson, if at your own expense, if you want to provide Ms. Anderson with a new car seat for her to keep, then you can do that. If you would rather have a high-end car seat, but otherwise the car seat that she has is acceptable. There's no evidence to the contrary. So again, if you don't like that car seat, you need to buy her a new car seat, and that'll be her car seat for the child. Do you understand that?
Yeah, but yeah.
Okay, and Ms. Schmitz, if he buys you a new car seat, use the new car seat, unless there's a reason not to. I mean, obviously, Mr. Gibson's going to spend a couple $100 and buy a new car seat. He's going to give that to you. He thinks it's safer, then by all means, use it. Okay?
Yes, Your Honor.
But you have checked with you gone to the sheriff's department, Ms. Schmitz, and the car seat that you currently use has been approved by law enforcement. Is that correct?
Yes, Your Honor.
Who did you take it to? City Monroe Police or the Monroe County Sheriff's Office or the State Police?
I had it approved through the city police office, and when one of my visits was denied, the patrol cop also okayed my car seat.
All right. And that was a City of Monroe officer as well?
Yes.
All right. All right, Mr. Gibson, do you have any questions?
No, Your Honor.
All right, Mr. Goldman, is it necessary to voir dire your clients regarding this recommendation?
I don't believe so, Your Honor.
Why have the parties chosen this exchange at a corner on Adams and 6th? And there's no traffic around there? Are they better off just exchanging at the City Monroe Police Department?
It's near the children's bus stop, Your Honor.
Okay, all right. So both parties agree this is the most convenient to make the exchanges then when the children are getting off the school bus. Is that correct?
Yes, Your Honor.
All right. Thank you, Mr. Goldman. All right. All right. The court will adopt the recommendation of Ms. Mayville. Thank you, Ms. Mayville. A copy mailed out to both of you. Please comply with the orders of this court, Mr. Gibson. If you have an issue then about parenting time, then you need to file a motion. You just can't unilaterally deny parenting time. You got to file a motion with this court and ask the court to modify parenting time. Understood? Mr. Gibson?
Yes, sir.
Okay. And so the other matter before the court this morning, you filed an objection to this court's order of January 24th. There's no basis for the objection. If you disagree with it, you need to file a motion to modify that order. You just can't object to it. It's not a referee recommended order. It's an order of this court. You need to file a motion to modify the order or you can file an appeal with the Michigan Court of Appeals. So the court will deny your objection because it's not appropriate. So with that, that will conclude the matter. Court will adopt the recommendation. Copy of both these orders will be mailed to both of you. Thank you, Mr. Goldman, and then thank you, Ms. Mabel. Okay, everyone can zoom out. Have a good rest of the day.
Thank you, Your Honor.
Thank you.
Welcome.
Thank you.
Please down session, middle of page 2, Jennifer Brandt versus Dustin Carson.
The record is matters before the court on the objections filed by defendant Justin Carter to a recommended order. Unclear whether there's a recommended order of January 25 or January 17th, which denied his motion to modify child support because he failed to appear. In any event, this hearing is being conducted via Zoom. Ma'am, are you Jennifer Brandt?
Yes.
Okay. Mr. Carter was the one that filed this objection, and he was one that secured the hearing date from the clerk's office. But he appears he has failed to appear. This matter was scheduled for hearing at 11 a.m. It's now 11:25 a.m. So the court will sign an order stating that it's unclear what hearing defendant is objecting to. Defendant did not appear. The objection that defendant filed was dated January 25. That's dismissed. Any referee recommended orders in the 21-day objection waiting period as of today's date are adopted as an order of the court. Right, you'll be mailed a copy of this. I'll conclude this hearing. Thank you for appearing this morning, ma'am. And have you heard from Mr. Carter at all this morning? By any chance?
No,
Right.
I've heard of
Okay.
him for a few years now.
He sort of wasted the court's time and your time having to appear. He's the one that filed this. It's I don't know what he's talking about. It's confusing what he's objecting to. But anyway, he failed to appear. So, all right, thank you for appearing, ma'am. You can, we'll conclude, you can mail the copy of this.
All right, thank you.
Welcome. Good morning, good afternoon, Ms. Rourke.
Good afternoon, Your Honor.
He was in his car, so.
Your proposed judgment was submitted on base, which has sort of jumped the gun. You should probably always wait to submit a judgment until after a court hearing because the clerks put it on base, and I'm glad I didn't sign it yesterday because I knew we had a hearing today.
Oh, I apologize, Your Honor.
And the clerk's office doesn't know, so the attorneys should be careful when they submit that judgment. They submit the clerk's office, immediately goes on base, and I have dozens of orders every day that need to be signed. Sometimes I don't even look at them. So just a word.
Okay, I apologize. I didn't realize that they went into on base immediately. I had just submitted them in anticipation of the hearing today, so I will not do that going forward.
Always wait till after the hearing.
Certainly, Your Honor.
Thank you.
Court is now in session, top of page 3, Michelle Roberts versus Christopher Roberts.
For the record, this matter is before the court on the plaintiff's motion for entry of a proposed judgment of divorce. This hearing is being conducted via Zoom. Present is Attorney Leah Rourke, representing the plaintiff, Michelle Roberts. Ms. Roberts appears to be present. In addition, Attorney Elias Muwad is present, representing the defendant, Christopher Roberts. I don't know, is Christopher Roberts, are you present, Mr. Roberts?
He is not. He is not, Judge.
Okay. All right, so I understand the issue is all about this parcel of property up in Emmett County, Clare, Michigan.
That matter has been resolved. I withdraw the objection to the entry of the divorce judgment, and I would agree that it's time to get entered.
Okay, the court would like you to approve that judgment, Mr. Muwad. Maybe if, again, just so that it's clear, because we have a motion filed, we have objections, other than just simply statement on the record. The court wants there to be a clear line so that people understand that we have a consent judgment. Are you willing to approve that judgment?
Yes.
All right. So, Ms. Rourke, I don't know if you want to, even if you just to the last page, the clerk brought up a number of copies. I'm reluctant to sign it without Mr. Muwad's acknowledgement on the piece of paper that he's approved the judgment. I suppose one option is I could sign the judgment today that you submitted and just indicate that Mr. Muwad approves of, as a result of a Zoom hearing today. I could do that if everyone's comfortable with that.
Your Honor, the judgment that we submitted, again, I realize I did it incorrectly, but in anticipation of the hearing today, varied slightly from the version that we submitted under the 7-day rule that was objected to. It was a small variation on page 4. The correct judgment in the last paragraph under real property includes the parcel identification number for the property located in Clare County.
I do note that, but I think that with these changes, the court's more comfortable. You can just submit this judgment to Mr. Muwad. Mr. Muwad, when you receive this, you will promptly approve the judgment. If you can docu-sign it or something of that nature and get it back to Ms. Worker so we get this judgment entered without further delay.
Sure, we can do that today if she'd like. That's not a problem.
Okay.
I did send it to him as well with the motion.
Judge, Ms. Ruka can sign my name with consent. I'll state that on the record. She can sign my name with consent.
All right. So, Ms. Work, if you actually come over to the courthouse today or whenever your schedule permits, I've got the originals up here. If you want to, then you can sign your name, and you can also indicate Mr. Wad for his approval. If you want to put some notations on this judgment, I'll sign it this afternoon.
Okay, thank you, Your Honor.
All right. Will that resolve everything then?
Yes.
It does, Your Honor.
Okay, because I do note that someone did send me an exhibit where we finally got a warranty deed relative to that property is now titled in Mr. Roberts' name. So, as I recall, this triggers in a payment to Miss Roberts, correct?
It does, Your Honor.
Triggers a $20,000 payment, Judge.
Okay. So, is Mr. Roberts prepared to immediately pay that?
Your Honor,
I believe so, Judge. Or go ahead, Leah.
I was just going to say, as a point of clarification, this was the issue, and in the motion, I did address defendant's objection. Their agreement, as reached by the parties in November, was that $20,000 would be paid to my client for her share of that property by February 1st. There was no mention or issue of a quitclaim deed until defendant's objection was filed, and that is where they requested that the agreement be amended to either when the deed was recorded. So the actual, from our perspective, the recording of the deed had nothing to do with the payment due date.
Understood. Okay. But we're in the judgment today, so Mr. Muwad, can you contact Mr. Roberts today and tell him to forthwith send that $20,000 check?
I hear you, Judge. Absolutely.
So, Ms. Rooker, if that's not received in the next 7 days and should be in a position to do that, then you can come back and the court will assess, we'll impose interest on it.
Thank you, Your Honor.
So please make that phone call to Ms. Roberts. Will that be sent to directly to Ms. Roberts or will it be sent to counsel?
Ms. Roberts, Your Honor.
Okay. All right. Hopefully that, so if you can please contact Mr. Roberts, have him, let him know the judgment's being entered today and that he should forthwith get that check off this week. If not tomorrow.
Okay, Judge. I hear you.
Right, that'll conclude the matter, Mr. Work. If you come over this afternoon, you can approve the judgment and the court will sign it. And now, take care of this matter. Thank you both.
Thank you.
You're welcome.
Thank you, Your Honor.
The parties have conferred with the front of the court. The front of the court has provided fine recommendation is that the party shall use app close for all communication. The communication should only be regarding the minor child. So obviously that's what your client is seeking. Is that correct, Mr. Jeffers?
That's correct, Judge.
Right. Mr. Lawson, do you understand the recommendation?
Yeah.
Anytime there's an issue about communication, the court will always order app close because it's reduced to writing and we've got copies. We know exactly what's being said. And then the court can make sure it's all constructive communication. It's not meant to intimidate or harass the other party, but simply to only right in the interest of the minor child. Any questions about this recommendation, Mr. Lawson?
No, sir.
Okay, you set up the app on your phone, and that should do that today. And all future communication shall be app close only regarding the child.
Gotcha.
Mr.
I did have a
Jeffrey?
question.
Go ahead.
So regarding the visitations, so as of right now, I'm unemployed, so I can't pay those. The $50 for every class. So I was just curious how many classes that would be, because I did ask the people when I went, and they said that they're not sure, that it's up to you guys.
I'm not sure what class you're talking about.
You guys sent me to the parenting counseling place to see my daughter every week.
Your Honor, his
Okay.
parenting time is at family counseling and shelter services.
Yes.
Okay.
So I was just
Let's see, okay.
curious how long the time period for that would be.
There was no set time. Basically, you talk with the people at that agency. If they feel that there's really no purpose served, that things are going extremely well, and they'll send reports in front of the court. And in fact, they think it's time that we can eliminate those supervised parenting sessions. Then you bring it to we file a motion with the court and ask the court to eliminate the supervised parenting time. Again, this order was just entered in October. How many sessions have you had so far?
I was just curious and how many it would be, because they told me it's up to you guys and when you guys would stop the classes. So they said they don't have no say so in that. They just report to you guys.
In answer to your question, there is no set numbers. So I
Gotcha.
think it just depends how things are going. If you're seeing your child on a weekly basis and things are going well, it's something you talk with Ms. Johns about. And obviously you want to get a positive letter from your counselor or from the therapist at that agency. And if you cannot afford the $50, then ask them if they can work with you on a sliding scale basis.
Your Honor.
I don't know if that's possible. The other thing is, in front of the court is a 4-page list of employers that are screaming for employees. I can get you a job today, Mr. Lawson, if you really want one.
Yeah, I do.
Michigan Bar, looking for dishwashers. Jack's Lawn Service, in front of the court is a 4-page list. Come by and get that 4-page list and look at those. They're either good paying jobs.
That's in Monroe, right?
Monroe County, front of the court. That's correct. And you get the one who's asked for a copy of the employment list. They update it every month. Ms. Brower can help you. Ms. Johns, you had a question?
His visitation rights got terminated as of February 1st.
Okay, the court was not aware of that. Why were they terminated? By whom?
By the visitation place. They filed something with the court. Evan called me and told me because he didn't show up 3 times that they filed something with the court.
And I called them and informed them that I didn't have a job.
He never called me after that.
But Mr. Lawson, it's a problem when there's a no show, no call. I mean, if you cannot make it or you're sick, you call and you cancel ahead of time.
I did call and I did let them know that I didn't have a job.
Hold on. To have Miss Johns show up with the child, you got a counselor that has blocked out an hour time, and for nothing, you don't call or show. But I'm not aware of any cancellation. So maybe they communicate back to the front of the court. So what we should do is communicate with them and just say, I regret that, and see what you can do to get back on track with those sessions, Mr. Lawson.
I did call and I did inform them that I didn't have a job, so I wasn't going to call them until I was ready and stable with another job to keep doing the visitations. I didn't know that I still had to call them every week after that to inform that I wasn't going to come.
Well, no, if it's not been scheduled, no, you shouldn't have to call them every week. But again, obviously, I don't know why. I don't know, Ms. Johns, you say that they canceled them. I don't know what you're talking about. Mr. Brown, perhaps you can explain to the court what's going on?
Your Honor, we do not have any letters from family counseling saying that they are not allowed back at the agency.
All right. So, Ms. Johns, I'm not sure we're getting that information. So, Mr. Lawson, all you got to do is once you are in a position to pay that fee, then call them and set it up. Gotcha. Reach out to Ms. Johns and make arrangements for the child to be brought to you. So, do that as soon as possible.
Gotcha. Thank you, sir. That's all I was curious about, because I knew I called him and talked to him. I shouldn't be not allowed to go back, So.
Right. The circuit court fund would pay for the intake costs, so that's currently all presumably been done, but you should pay for the individual sessions. So make it work. You want these visitations to go at least every week, if not every other week, if not every week. You need to establish a relationship with your child, and then you can get away from this expense, and the child come to your home. That's the whole goal here.
Gotcha.
So
I know. Trust me, I'm trying.
Secure employment, get the funds, and call the agency to get back on the list, right?
Yes, sir.
And then you ask how long. Well, I guess that's how it's going. If things are going real well and you're being consistent and the visits are going well, then you ask your counselor to the supervisor to write a letter to the front of the court. The front of the court receives all communications from that agency. And then you can file a motion with the court saying, hey, it's time that we can break loose that. We don't need it anymore.
Gotcha.
Okay. Mr. Jeffers, anything you want to add?
I just have one question. How many visits did you have before you stopped going, Mr. Lawson?
I think I did one, and then I got COVID, and then like I think she canceled one also one day. Then went to go the next day or something like that.
Okay.
Or I don't know. It was something came up. I'm not sure, but I know I
They
was
canceled
sick.
one. They canceled you. Okay, you showed up the first time. The second time you had probation, so you had to cancel. Then the third time you had COVID. The fourth time they rescheduled, and then the fifth time because of the roads in the snow, and then the
Oh
fifth
yeah.
time, you were no call, no show because I was already there when they told me that you weren't showing up. And then that's when he said he was going to file something with the court to terminate. And then on February 1st is when he called me and said that they got back to him and said that they terminated your rights until further notice.
Okay. I was just
All right,
curious how many visits we had to know what to expect for the future.
Yeah.
Sure. All right. Good question, Mr. Jeffers. All right. So, Mr. Lawson, in front of the court, not aware of being terminated, you need to call that agency to verify or not. And, but probably wait to get the $50 together. But you want to make sure this child knows who you are. The longer you delay this, the harder and longer it's going to take. You need to have
Yeah, no,
very
I understand.
child.
Trust me, I'm trying. I can't do nothing without a job. I'm trying. Once I get that and establish another job, then I'll be fine.
We'll come down in front of the court today and get a copy of that jobs list.
I will. I owe you guys some money too for a ticket. So
okay, all right. Anyway, the court will adopt the recommendation. Thank you, Ms. Brower. The copy we mailed to both of you. Load that app post on your phone.
All right, thank you.
Thank you, Judge.
You're welcome. You're welcome.
Ms. Johns, I'll
Zoom
have
out.
Francisco give you a phone call.
The plaintiff, Mark
All right, thank
Grant.
you.
Mr. Grant, Mr. Grant appears to be present with Mr. Francisco. In addition, Attorney Maria Zagorski is present representing the defendant Victoria Grant, and Ms. Grant is present with Ms. Zagorski. The court has been informed the parties have reached short agreement. Is that correct?
It is, Your Honor.
Wonderful. Who would like to place that agreement on the record?
I can, Your Honor.
Mr. Francisco, please.
Thank you, Your Honor. So the total agreement is defendant is to pay plaintiff $19,000 within 30 days of the judgment. My client, plaintiff, will sign over his name off of the trailer title. Defendant will sign her name off of the title to the 2009 Explorer. The joint third bank account will be awarded to a plaintiff. Defendant will remove her name from that account. All other accounts will remain in the party's sole names. All debts are kept in their respective names. All life insurance policies were also kept in the respective parties' names, and spousal support will be barred to both parties.
Thank you. And I'm sorry. What's the time frame for payment of this sum of $19,000?
Within 30 days, Your Honor.
Of entry of the judgment?
Yes.
All right. Thank you. Ms. Zagorski, Mr. Francisco accurately state your client's agreement.
Yes, Your Honor. The court should also know the 2009 Ford Explorer is being awarded to Mr. Grant outright, and my client may have her prior name restored to her if she so elects. Additionally, because my client remains in the marital home, she is in possession of some things that belong to Mr. Grant, and she will make those available to him at a mutually agreeable time so the parties can amicably divide their personal property. My client has some of his family heirlooms, his recliner, and some personal effects like his CPAP machine, and she will, of course, return those to him at a mutually agreeable time and date.
Sooner the better.
Yes.
What about 2023 tax returns? Are the parties going to file separate or to join?
We don't file.
The parties are both on Social Security, have no other income, so they don't file returns, my client indicates.
Thank you. All right, Mr. Francisco, if you're going to begin with Mr. Grant, please.
Yes, Your Honor. Thank you. Mr. Grant, could you please state your name for the record?
Mark Linden Grant.
Thank you. And were you a resident of the state of Michigan for at least 180 days prior to the filing of this complaint?
Yes, sir.
And were you a resident of the county of Monroe for at least 10 days prior to the filing of the complaint?
Yes, sir.
Okay. Is your wish to be divorced?
Yes.
And do you believe that there's been a breakdown in the marriage relationship to the extent that the objects of matrimony have been destroyed? There remains no likelihood that the marriage can be preserved?
Yes, sir.
Did you hear the agreement that was placed on the record?
I did, sir.
And was that an accurate statement of the agreement?
Yes, sir.
And you understand that agreement?
Yes, sir.
you had enough time to think about and decide on that agreement?
Yes, sir.
And do you believe that this agreement is in you and your wife's best interests?
I do, sir.
Are you satisfied with my services?
Your services were excellent.
You're agreeing to these terms of divorce, knowing that you were entitled to a trial in this matter?
Yes, sir.
And you're waiving your right to trial?
I do, sir.
Okay. And you agree and understand that you're waiving any right to any child support, or sorry, not child support, my apologies, spousal support, and you agree that it'll be forever barred between you two?
I do, sir.
No further questions, Your Honor.
Thank you, Mr. Francisco. Ms. Gorski, do you have any questions, first of all, from Mr. Grant?
Just one. Mr. Grant, have you disclosed all of your assets?
I'm sorry. Would you please repeat the question?
Sure. Have you disclosed all of your assets during these negotiations?
To the best of my knowledge, yes.
Okay, thank you. That's all I have for him.
Thank you, Ms. Gorski. Questions for Ms. Grant, please?
And you heard your husband's testimony today?
I did.
Was everything that he said true and accurate?
As far as I know, yes.
Okay. And are you pregnant?
No, I am not.
And you likewise understand that that these terms, if the court accepts them, are binding and
Right.
final,
Yes, I
right?
do understand that.
And you can never come back and ask for spousal support.
That's right.
You can never come back and ask, for example, that you be awarded the Explorer, that you pay Mr. Grant less money. You understand?
I do understand.
Okay.
yes.
You understand, and we've talked about this, the judge could schedule a trial in this matter, and he could decide that a fair and equitable resolution would be for you to get more money, less money, or what you're agreeing to today.
Okay.
You understand that?
I do.
Okay. And you understand if we agree to this today and the judge approves it,
Mhm.
that you will not have that trial.
Right.
And that's your wish
I
today.
understand that. Yes, that is my wish today.
And you're asking the court to adopt this agreement?
I am.
Okay. Do you have any questions?
No, I do not.
And have you disclosed all of your assets?
I have.
Okay. Thank you. That's all I have of my client, Your Honor.
Thank you, Ms. Gorski. Mr. Francisco, do you have any questions of Ms. Grant?
No, Your Honor. Thank you.
And Mr. Francisco, you'll prepare the judgment?
I will.
All right, thank you. Very well. The court would like to thank and acknowledge Mr. Walker for his fine assistance in helping facilitate amicable resolution, as well as, of course, attorneys Francisco and Zagorski. The court would applaud you, Mr. and Mrs. Grant, for reaching your own agreement. Without question, the best resolution of a matter of this nature is one in which you both participate and ultimately agree upon as you have this afternoon. Keep in mind, you'll not be legally divorced until the court signs written judgment. Hopefully that will be in the next couple of weeks. Based, however,